Have you ever been in that situation where work demands just totally clash with something critical, like a doctor's appointment? Now, what if that appointment isn't just, important? What if it's for an injury you actually got on the job at the Postal Service? For USPS folks, this isn't just hypothetical. It's a real worry, especially with OWCP claims.
Exactly. And that's really why we're here today doing this deep dive. Our mission basically is to make sure you know your rights. We want to clarify those non-negotiable legal rights, explain why they're there, and give you a clear roadmap so you get the care you need. No interference.
That sounds absolutely crucial because what we've dug up, it's not just laws and, arbitration rulings. There are some...
The simple answer, no, absolutely not. The foundation for this is the Federal Employees Compensation Act, FECA. That's federal law. And it's really clear. It says the government must provide all the medical services your doctor prescribes that are likely to help you recover. It's not like a suggestion. It's a requirement.
A requirement, okay.
And get this, USPS's own rulebook, the ELM, the Employee Labor Manual, Section 545.53, backs this up completely. It literally says, Postal Service personnel must not interfere with the medical care prescribed by the employee's attending physician.
Wow, their own rules.
Yeah, so management cannot pressure you. They can't tell you to delay. They can't make you miss appointments your doctor says are necessary.
Okay, that seems pretty ironclad. But what about, that thing that comes up a lot? What if USPS says, okay, fine, but we want you to see our doctor, a contract doctor? Does that appointment trump mine?
That's a really common question, yeah. And sometimes it feels like a tactic. But the rule here is also super clear. USPS can ask you to see their contract doctor, maybe for an evaluation. But that exam, and this is the key part, must in no way interfere with the employee's right to seek prompt examination and further treatment from a physician of choice.
So their evaluation can't delay my actual treatment.
Exactly.
Yeah.
It simply cannot get in the way of your scheduled care with your own chosen doctor. Your appointment takes priority.
And we've seen this actually tested, right? There was that big national arbitration ruling, Mittenthal.
That's right, C06462. It specifically confirmed that any exam management requires cannot delay your own doctor's appointment. It's a landmark ruling.
And the NALC, the Letter Carriers Union, they advise the same thing too, don't they?
They do. They tell members, look, management might send you to their doctor, but the appointment should not interfere with your doctor's appointment. And crucially, you are never required to get treatment from that postal contract doctor. Just evaluation, maybe? So what's really fascinating here, when you put it all together, is how consistently the law, USPS's own policies, and union agreements all say the same thing. Your chosen medical care, the appointments your doctor prescribes for that work injury, they come first, period.
Your health comes first, basically.
It takes precedence over management's scheduling preferences. There's really no wiggle room there.
Okay, so the legal side is solid. Your right is clear. Now,
Great.
What happens if a supervisor just ignores all that? Or worse, deliberately tries to stop you? What are the actual, real-world consequences?
Right, because it's not just theory. This is where it gets very serious for management. The system has teeth. The unions, for one, are very aggressive about enforcing these OWCP rights. Like you said, that Mittenthal award was huge. Management cannot delay treatment. And there was another case, arbitrator Claude Ames. He found a supervisor didn't tell an injured worker about their continuation of pay rights.
Right.
The 45 days of pay.
Right, copy, yeah.
And he ruled that violated the national agreement. The grievance was sustained. The employee got remedies.
So messing with OWCP stuff is a contract violation.
Definitely. And arbitrators have ordered USPS to pay up lost wages, medical costs, if an appointment got missed because of management interference.
And it goes beyond grievances, doesn't it? What about, whistleblower laws?
Yes, absolutely. Interfering with your medical care can also be a violation under the OSH Act, the Occupational Safety and Health Act. That protects you from retaliation if you report an injury or seek treatment.
And wasn't there a pretty big court case recently, 2023?
There was. It was significant. A federal court ruled against USPS. They'd fired an employee who reported an injury and was pursuing OWCP benefits. The court said it was unlawful retaliation, ordered the employee reinstated, back pay, and this is huge mandated training for managers.
Wow, actual court-ordered training.
It sent a massive signal. If a supervisor threatens you, punishes you, disciplines you for going to your injury appointments, OSHA and the Department of Labor can step in. USPS even had to post notices in that workplace saying, basically, you have the right to report injuries and get medical care without fear.
Okay, so grievances, OSHA complaints, but you mentioned something even more serious earlier, something about criminal law.
Yeah, and this is something most people, even managers sometimes might not realize. There's a federal criminal statute, 18 U.S.C. Section 1922. It makes it illegal, actually a crime, for a federal officer to induce, compel, or direct an injured employee to forego filing of any claim for compensation or other benefits under FECA.
Forego benefits, like necessary medical treatment.
Exactly. Preventing a doctor or therapy appointment that's part of your approved OWCP claim could absolutely be seen as pressuring you to forego a benefit, the medical treatment itself.
And the penalty.
Fines, and up to 1 year in prison.
Prison. For stopping someone from going to the doctor for a work injury.
Potentially, yes. Now look, are criminal prosecutions common for this? Probably not. But the fact that this law is on the books, it's a huge red flag. It sends the clearest possible message. Messing with an injured employee's required medical care is completely off limits. Any supervisor should think very, very carefully before going anywhere near that line.
Oh,
Yeah, that's incredibly powerful, knowing that exists. Okay, so let's pivot to the practical. You're in this situation. Your supervisor is giving you grief about an appointment. What do you actually do, step by step?
Okay, first step. Documentation. Notify your supervisor and do it in writing. As soon as you have the appointment, submit a leave request. For postal workers, that's usually the PS Form 3971, or send an email. Clearly state the date, the time, and this is important, that it's for your job-related injury. Attach proof if you have it, like the doctor's note or appointment card, and always, always keep a copy for yourself. That paper trail is gold.
Okay, written notification, keep a copy. What's next if they push back?
Step 2. Politely remind them of the rules. You don't have to be confrontational, but be firm. You can mention USPS ELM 545.53, the rule saying they can't interfere. You could even mention the federal law, 5 U.S.C. 8103A, guaranteeing the treatment. And remind them, look, you can ask me to see your doctor, but it can't delay this appointment. Honestly, often just showing you know the rules, maybe even citing the specific section, makes them back off fast. Right, showing you've done your homework. Okay, step 3.
Don't fight this alone. Step 3, involve your union steward immediately.
Call the union. Good advice.
As soon as you smell trouble, get your steward involved. They can file a grievance right away. Remember, messing with your OWCP rights is a violation of the contract, Article 5 usually. The union knows the regulations. They know the arbitration awards like Mittenthal. A formal grievance is often the quickest way to, let's say, educate a supervisor about their mistake.
Okay, so notify in writing, remind them of the rules, call the steward. What if they still say no or threaten you?
Right. This is critical. Step 4, do not cancel your appointment. Your help comes first. Your claim depends on it. If they refuse leave or threaten discipline, you need to politely but firmly state your position. Something like, I understand your concern, but I am required to attend this prescribed medical treatment for my work injury. Preventing me could violate federal law and OWCP rules.
Okay, stand firm, state the facts.
And document everything. Who said what, when, any witnesses. Then you escalate.
Escalate how?
Several paths. If they actually discipline you or harass you, file an OSHA whistleblower complaint. Section 11C of the OSH Act. You generally have 30 days, so act fast. Also, notify the USPS Injury Compensation Office. These claims are supposed to be managed above your direct supervisor's level. Let the specialist know about the obstruction, and you can contact OWCP directly or the Department of Labor. Your claims examiner can make inquiries, intervene, let USPS know they're watching. DOL have legal remedies too.
So multiple official channels to report this.
Absolutely. And connecting back to step 1, that documentation. Emails, lease slips, notes on conversations, witness names. That paper trail is your best friend in any escalation. It often makes management back down quickly when they realize an investigator or an arbitrator will see their actions laid out in black and white.
Okay, that makes sense. Documentation is key. What's step 5?
Step 5 is simple but crucial. Prioritize your health. Attend the appointment.
Just go.
Yes. Do not skip it because of pressure. Skipping hurts your recovery, obviously, but it can also jeopardize your OWCP claim. OWCP can actually deny benefits if you refuse necessary treatment. So, plan to go as scheduled. Let your steward know what's happening. When the time comes, politely inform your supervisor, I'm leaving now for my scheduled medical appointment for my work injury, and go.
Okay. Attend the appointment period. And finally,
Step 6, follow up and make sure you get paid correctly for the time. If it's a traumatic injury and you're still in that 45-day COP window, the time should be coded as continuation of pay. You get your regular wages. If COP is over, or it's an occupational disease claim, you might use sick leave, annual leave, or leave without pay initially. Then you file a Form CA-7 with OWCP to claim wage loss compensation for that time off. That's your right.
and what if the supervisor tries to mark you a wall? Absent without leave.
If they do that as punishment, grieve it immediately through your union. That's blatant retaliation. Management would almost certainly lose that fight in arbitration, especially with your documentation.
Okay, that's a very clear plan. Thank you.
So let's just bring it all together. The bottom line is this. USPS supervisors cannot legally stop you from going to doctor appointments for your on-the-job injury. They simply do not have the authority to make you miss medical treatment that your own physician says is necessary for your recovery.
And any attempt they make, it can violate USPS's own rules, those big arbitration awards we talked about, and federal law. It exposes them and the Postal Service to grievances, OSHA complaints, legal penalties.
And potentially, though rarely, even those criminal charges under 18 U.S.C. Section 1922.
Right.
So when you're armed with this knowledge and you have your union and federal agencies ready to back you up, you really can stand firm and assert your right to get the medical care you need.
So what does this all really mean for you listening right now? It means your health, your recovery from a work injury. It should never play second fiddle to postal schedules or a manager who doesn't get the rules. The law is squarely on your side here. And if, unfortunately, you run into a supervisor who isn't, let's say, wise enough to understand that, you now have a clear step-by-step plan. You can protect yourself and make sure nobody stands between you and the medical care you're entitled to. Stay informed, be ready, and please don't hesitate to use a protective